Welcome to Innovative Brains. Today we will learn Patent Amendment Rules 2024. The draft of Patent Amendment Rules were published in Gazette of India on 22nd of August 2023 and came into force on 15th March 2024. Let's start. First one is the amendments to Rule 12 of the Patent Rules 2003 update the procedure for patent applications, particularly related to the information provided about foreign patent filings. First one is change in deadlines for filing information. Sub-rule 2. Under old rule, you had 6 months from the date of filing a patent application to submit the required information about foreign patent applications through form number 3. According to new rule, now you have 3 months from the date the first statement of objections is issued. Based on rules 24B or 24C, this cuts the original time period in half and ties it to when objections are raised, not the filing date. Second one is substitution of sub rule 3. Under old rule, the controller was expected to get information about foreign filings through the applicant. According to new rule, the controller can now access and use publicly available databases to check the information about the applicant's foreign filings. This reduces the burden on the applicant to provide this data themselves. Third one is fresh statement requirement. Sub-rule 4. Under old rule, the applicant only needed to file form number 3 when foreign applications were filed or granted. According to new rule, the controller can ask the applicant to provide a fresh statement about foreign filings and give them 2 months to do so. The reason for this request must be recorded in writing. Fourth one is condonation of delay. Sub-rule 5. According to new provision or amendment, even if the deadline for filing form number 3 is missed, the controller can allow a 3-month extension if the applicant makes a formal request using or through form number 4. This offers some flexibility to applicants who might miss the original deadlines. In summary of this amendment, the changes makes the rules stricter with tighter deadlines, but also allow the controller more flexibility in gathering information from external databases and give applicants a chance to request extensions when needed. Next is this amendment to Rule 13 introduces more flexibility for patent applicants when filing additional or further applications under section number 16 of the Patent Act. Under Old Patent Act 1970, under section 16, the applicant could file a further application, also known as divisional application, if their original application contained more than one invention. The divisional application allowed them to claim different inventions separately from the original. And according to new amendment, the amendment adds a new sub-rule 2A to Rule 13, which states that an applicant can file one or more further applications under section number 16. These further applications can be based on either the invention disclosed in the provisional or complete specification of the original application or another further application already filed under section number 16. What this means? First one is more flexibility. Now, if an applicant finds that their original patent application covers multiple inventions, they can file multiple further applications, means divisional applications, to cover each of those inventions. They can even base a new further application on an earlier one if needed. Second one is clearer scope. This ensures that the applicant can secure protection for all inventions disclosed. whether in the provisional or complete specification, through as many divisional applications as required. In summary of this amendment, compared to the old rules, this change gives patent applicants more options to file additional applications for invention in different stages, helping them secure broader patent protection. This amendment to Rule 24B of the Patent Rules 2003 makes significant changes to deadlines and procedures for patent examination. First one is reduction in time limit for requesting examination, Sub Rule 1. Under old rule, before amendment, applicants had 48 months from the date of filing their patent application to request an examination under Section 11B. According to new rule, after amendment, this period is now reduced to 31 months, so you have less time, just over 2.5 years, to make a request for your patent to be examined. Second one is clause for applications filed before the new rules. New clause 6. According to new provision for patent applications filed before the Patent Amendment Rules 2024 come into effect, the old 48-month period will still apply. Means, if you filed your patent application, before these new rules were introduced, you will still have 48 months to request an examination. This ensures that rule change does not affect older applications and provides a transition period. Third one is clarification in time limits for processing, Sub Rule 6. Under old rule, the timeline for processing after an examination was referred to as being specified under Sub Rule 5. According to new rule, this phrasing is replaced by specified herein, making it clear that the relevant timelines are directly stated within the current rule, not just in Sub-Rule 5. Summary of key changes. Means summary of this amendment. First one is the time to request a patent examination is shortened from 48 months to 31 months for new applications. Second one, older applications filed before 2024 amendments will still follow the old 48-month timeline. And third one is a small wording change clarifies that all time limits are stated in current rules. This amendment speeds up the patent examination process for new applications while protecting older ones from sudden changes in the rules. Next. Fourth one, this amendment to Rule 24C of Patent Rules 2003 makes a small but important change to clarify the reference to time limits. Under Old Patent Act 1970, means before amendment, in Sub-Rule 11, the timelines for actions were referred to as being specified under Sub-Rule 10. This meant the deadlines for certain actions under Rule 24C were indirectly linked to Sub-Rule 10 amendment, means after the change. The words specified under Sub-Rule 10 are now replaced by specified herein. In simple term, this means the time limits are now clearly defined within Sub-Rule 11 itself, rather than being cross-referenced to Sub-Rule 10. What does this change mean? The new wording makes the rule clearer and more self-contained. You no longer have to look at Sub-Rule 10 to understand the deadlines mentioned in Sub-Rule 11. Everything you need to know is now directly in Sub-Rule 11. Comparison with the old Patent Act 1970. The previous system required looking at another sub-rule, Sub-Rule 10, to determine the applicable timelines, which could cause confusion. And the new system simplifies things by directly stating the deadlines within the same sub-rule, reducing the possibility of misunderstanding of mistakes due to cross-referencing. Summary of this amendment. This is a clarification and simplification of the rule, making it easier to understand the deadlines within subrule 11 without needing to refer to another subrule. The amendment does not change the actual time limits but makes the rule easier to follow. Next, 5. Fifth one is the introduction of Rule 29A in Patent Rules 2003 brings clarity on how to avail of the grace period provided under section number 31 of Patent Act. According to Old Patent Act 1970, means before amendment, in the old rules there was no specific procedure mentioned for claiming the grace period under section number 31, which deals with exceptions to anticipations, that is, disclosures that do not count as prior art like certain exhibitions or accidental disclosures. New amendment Rule 29A. A new Rule 29A is added titled Grace Period. It states that if an applicant wants to claim the grace period under section 31, they must: first one, file an application using form number 31. This is a formal document requesting the grace period. And second one, pay the prescribed fee as specified in the first schedule, means which is a detailed fee structure. What is section 31? Section 31 allows applicants to prevent certain types of disclosures from affecting the novelty of their invention. If the disclosure occurs under specific circumstances like showcasing the invention at an official exhibition or due to an unauthorized act, this is known as a grace period. Comparison with the Old Act 1970. Under Old Act, while Section 31 existed, there was no formal rule or procedure to claim the grace period. It was not clear how an applicant would apply for this benefit. According to new rule, the amendment creates a structured and formal way to apply for the grace period using form number 31 and the required fees, bringing transparency and order to the process. Summary of this amendment. New Rule 29A introduces a clear procedure for claiming the grace period provided under Section 31 by requiring applicants to file Form number 31 and pay the applicable fees. This amendment simplifies the process, making it easier for applicants to protect their inventions from certain disclosures that would otherwise impact their patent application. Sixth one, this amendment to Rule 55 focuses on the procedure for pre-grant opposition. Pre-grant opposition means when someone challenges a patent application before the patent is granted. According to Old Patent Act 1970, before amendment, the process for pre-grant opposition had less clear timelines and the procedures for hearing opponents were somewhat general, and the timelines for the controller's action and responses were broader. The structure of the hearing process was less detailed. Amendment to Rule 55. A. Change to Subrule 3, that is, new detailed procedure is added for handling representations, means opposition filings. What is the procedure if no prima facie case is made? The controller will notify the opponent in that 1. If the opponent doesn't request a hearing, the controller will pass an order within 1 month recording the reasons for rejecting the representation. Second one, if the opponent requests a hearing, the controller will arrange the hearing and then pass an order within 1 month of the hearing, explaining why the opposition is rejected or accepted. The applicant will be informed accordingly. Next is if a prima facie case is made, means that the opponent's argument has merit. The controller will within 1 month issue an order explaining why the representation is accepted and will notify the applicant. According to old rule, the older system was less specific in terms of deadlines and the procedure for handling the opposition was more open-ended. The new rule introduces clear deadlines and steps. Next, B is change B is change in sub-rule 4. According to old rule, opponents had 3 months to respond after being notified. In new rule, this period is shortened to 2 months, speeding up the opposition process. C is new sub-rules 5A and 5B. First one, sub-rule 5A. The procedure for hearings under this rule, Rule 55, will follow the same steps outlined in Rule 62, Sub-Rule 2 and Sub-Rule 4 of Rule 62. This means the formalities and processes used for hearings in post-grant opposition are now being applied to pre-grant opposition hearings. And according to old rule, the old procedure didn't clearly link the hearing process to Rule 62, which made the pre-grant and post-grant processes different. Now they align more closely. Second one, Sub-Rule 5B. If a patent application is opposed and the controller has issued a notice to the applicant under Rule 3, that application will now be examined under the process outlined in Rule 24C, which deals with timelines for examination. One second. Under old rule, there was no clear linkage between pre-grant opposition and the examination process, and this new rule ensures that applications under opposition are examined efficiently and according to strict timelines. Comparison with Old Patent Act 1970. Under old system, the older rules for pre-grant opposition were more flexible, with longer timelines, 3 months instead of 2, and less clarity on hearing procedures. There was no direct connection between opposition and the examination process. According to new system, the new rules provide clear deadlines, structure and link the opposition process more closely with the examination process. This helps avoid delays in handling patent applications that face opposition and streamlines the entire pre-grant opposition procedure. Now we will learn summary of this amendment. What is the summary? First one is clearer process, means a detailed step-by-step procedure is now in place for handling pre-grant opposition. Second one is shorter timelines, means deadlines have been reduced to speed up the process. Third one is alignment with post-grant opposition procedures. The hearing process is now more consistent between pre-grant and post-grant opposition. Fourth one, efficient examination, means if an opposition is raised, the patent application will be examined under the rules governing timelines, ensuring quicker resolution. This amendment makes the opposition process faster, more structured and more in line with the patent examination process.